Hi, in the heat of South Africa. How are you guys doing? I hope you are doing well, and welcome to today's episode of Vlogmas. With that said, do not forget to like, comment, and subscribe to this channel if you are into legal stuff and just vibes. By the way, AsandaNtini, and remember, none of my videos are legal advice. If you are looking for legal advice, please go and consult with a legal practitioner in their practice or a legal advisor, whichever one that you prefer. Anyways, with that said, let us speak about Bafana Mahungela. Let me check if I'm actually pronouncing that surname right, but I think I am. He is a 21-year-old accused of murder of a school teacher, and at first there were accusations of rape, but obviously with postmortem report showed that there was no actual penetration and before death. And so basically he's charged with robbery and murder. And this is why I'm speaking about this. I'm speaking to a candidate attorney who's going to be doing their bail. And I've done, I think at this point, I've done 2 videos on bail. I just wanna caution, rather. Yeah, I think the right word is to say. I wanna caution a person who's going to be doing a Schedule 6 bail, or even a Schedule 5, or any bail on that matter. Why are you putting the accused person on stand? At bail, you can do that at plea, because they're already pleading and already going on stand, saying that they've done this. But on bail, my guy, I'm sorry. I know that the person who's representing might be senior to me, but me as a practitioner, I'd feel that it's not wise, especially on a bail application, especially for a crime that serious, to put a person on stand, because the evidence that they are admitting to, that they are submitting to court on stand, is under oath and can be used against that person at trial. First of all, this person has placed themselves on the crime scene. They've put themselves there. So state no longer has a duty to actually say, how is this person linked to this person? He's already said, this is what I did. Could see the t-shirt. He could easily not mention it on his affidavit. But he couldn't do that because they put him on stand and he started speaking. He spoke. He's implicated himself so many times, and I really, really urge you that do not make the mistake of putting an accused person on stand during their bail application, because they are likely to implicate themselves. They also make the job of the state to prove certain elements very easily, like placing them on the crime scene. They've already placed themselves on the crime scene. They've said it under oath. They've explained how they were on the crime scene. State doesn't have to prove that anymore. So kudos to him for being on stand. I would think that it's not a wise decision to do. So if you are a candidate attorney watching this, trying to decide whether to actually put your client on stand for a bail application, don't do it. Prepare an affidavit, write it properly, look at all the elements of what you need to prove in a bail. In a bail, what you are doing is the person a suitable bail candidate? Are they, if it's, what's this? Is it in the interest of justice for him to be released on bail, or are there exceptional circumstances for him to be released on bail? Prove that, focus on that. What are you doing putting that person on stand to testify on what happened? Because the court is at bail, the court being the magistrate or whichever that you are doing the bail to, has a right at bail point to inquire, ask questions. And if the person is on stand, they're going to answer. No matter how much you tell your client, no, don't answer this, don't say this. They are going to answer because they would feel that they are helping. They would feel that they want to clarify things. The clarifying is what's going to let them not get bail. What you want at that point is for them to get bail. And also, when you are what just happened with this guy, people are thinking it's a trial. People, like, comments that we're getting everywhere. This trial is because it has turned into a mini trial because of the one I feel, because one of the mistakes that were made for this thing to now be a question of is the person guilty or not, which is not the question at bail. That's not the question. The question at bail is, will this person not run away if you give them bail? Is this person not in danger to himself or the society if we release them on bail? What will the reaction of? Those are things that you look at bail. And now people are just, and even the court, I'm pretty sure, not that they do that, but they have that in their ear. Maybe this person is actually very guilty. Okay, you are specifically dealing with Section 60 of the Criminal Procedure Act, which obviously says you can bring them in as a witness, but you can write an affidavit. Prepare a proper affidavit that settles all the questions that Section 60 has. Prepare your closing arguments in that sense as well, your address. And if you don't put them on stand, it won't be a mistake of Uguti. But you put me on stand, I had to answer those questions. So yeah, don't do that. It's not a trial yet. And then also, it confirms not just guilt to the court, but it also confirms guilt to the court of public opinion, because there's so much public opinion, media and everyone who has an opinion says this person is guilty, because the story doesn't make sense. It doesn't even make sense to me. I'd be like, this is wild if I'm consulting with you telling me that you decided to sugumisa a deceased person and take off their clothes and wear them. That's just wild. But things happen when you are in flight or fight mode. And yeah, but if you are not at the crime scene, you are not placed at the crime scene, we can't question that. Oh, I'm so sorry, it's so hot. We can't question that. But if you are placed on the crime scene, we will obviously question that. They're going to implicate themselves, and the victim's family is going to be they need somebody to blame for the crime that happened. Now, everyone needs somebody to blame for the crime that happened. And if Bafana has placed himself at the scene, Bafana has implicated himself so many ways, we're going to take him as court of public opinion, as victim's family. I'm sure even his family, some of his family members are like, you go to Bafana. So obviously, those things I'm not saying that they could have been avoided by just placing an affidavit, but I truly believe that as an accused person, exercise your right to remain silent. Place your circumstances, prove that you have exceptional circumstances, or it's on public interest that you be released on bail, permit that you be released on bail, and say nothing further about anything else. It's that simple. And say nothing further. And your client, I'm not saying that they're gonna walk out with bail, because there are so many things that determine bail, but you're likely to not feel bad for placing them on the stand and helping the state's case if you actually didn't put them on the stand. With that said, let me know, what do you think about this whole matter? And remember, it's not a trial yet, and he's not been convicted yet. It's still a bail application, and the bail, I think it was denied not yesterday, on Friday. But it's still at that stage. Probably investigations have not been finalized as yet. But now, obviously, everyone with him, especially with him being denied bail, everyone is like, okay, he's guilty, unfortunately. And obviously, one is guilty only once they've been found guilty by the court of law. At this point, he's still an accused person, and maybe he could still bring a bail on new facts, or a bail, appeal the bail decision, whichever decision that they decide to do. There's still so much that can be done. But yeah, candidate attorneys, please, I beg, if there's one thing that I can say I'm advising as a candidate attorney, don't put your client on stand during bail application. It's the best thing to do for your client, I think. Anyways, that said, please let me know, have you put an accused person on bail, especially charged for a Schedule 6 offense, and did they actually not implicate themselves once you put them on the stand? Let me know. Love you lots, and yeah, let me go and deal with this heat. Bye.